If you live in North Carolina and you drive a car, ride a bicycle, or walk near traffic, there's a legal rule in this state that could determine whether you recover anything after an accident. And most people have never heard of it until they're already dealing with the aftermath. It's called contributory negligence, and North Carolina is one of only 4 states in the entire country that still uses it in its pure form. I'm Michael Harmon, a North Carolina personal injury lawyer, and I want to spend some time today giving you a clear understanding of what this rule is, where it came from, how it works in real life, and what it means for anyone who gets hurt because of someone else's actions in North Carolina. So what is contributory negligence? In most states across the country, fault in a car accident is treated as a percentage. If you were 20% responsible for a crash and the other driver was 80% responsible, you can still recover. You just recover 80% of your damages instead of the full amount. That system is called comparative fault, and it's the law in 46 states. North Carolina operates under a completely different standard. Here, if you're found to be even 1% at fault for an accident, you can be barred from recovering anything at all. Not a reduced amount, nothing. That's not a typo. 1% of fault. A jury deciding that you share even the tiniest bit of responsibility for what happened can wipe out your entire claim. It doesn't matter how badly you were hurt. It doesn't matter how reckless the other driver was. That's what pure contributory negligence means. And it's the legal reality for every person injured in North Carolina. Where did this rule come from? Contributory negligence isn't a new idea. It dates back to the 19th century English common law and was carried over to the American legal system in the country's early days. The original thinking was simple. If a person played any role in causing their own injury, they shouldn't be able to hold someone else fully responsible. Courts felt it was unfair to make a defendant pay for damages when the person suing them had also made mistakes that contributed to what happened. Over time, as cars became more common and accidents became more complicated, state after state began to recognize that this rule was producing outcomes that were deeply unfair to injured people. A pedestrian hit by a drunk driver who happened to be walking slightly outside a crosswalk could recover nothing. A driver struck from behind who was going 2 miles per hour over the speed limit could recover nothing. The harshness of the rule was hard to defend. States began switching to comparative fault systems, recognizing that fault in an accident is almost never completely one-sided, and that reducing what someone recovers based on their share of the blame is far fairer than cutting them off entirely. Again, today, 46 states use some form of this comparative fault. North Carolina, Virginia, Maryland, and Alabama are the last states still using pure contributory negligence. So how do insurance companies use it? Understanding that contributory negligence exists is one thing. Understanding how insurance companies use it as an active defense tool is another. And this is where real-world impact of the rule becomes clear. When an insurance adjuster receives a claim, one of the first things they look for is any evidence that the injured person played even a small role in causing the accident. They're not looking for a lot of fault. They're not looking for fault that was significant. They're looking for any fault at all, because even the smallest amount can eliminate the claim entirely. This shapes how adjusters approach the days immediately after an accident. They'll reach out quickly and ask for a recorded statement before you've had time to fully process what happened, before you've talked to anyone about it, and before you understand what your words could mean legally. The questions they ask are designed to draw out small admissions. Were you familiar with that intersection? Had you driven that road before? How fast were you going? Did you see the other vehicle before it impacted? A casual answer, yeah, I drive that road every day. I was probably going about 40, can be built into a contributory negligence argument that ends your claim entirely. They'll also look at the physical evidence from the scene. Where your vehicle ended up, where the impact occurred, how fast you were traveling. All of it gets examined for any sign that you contributed to what happened. The last clear chance doctrine. North Carolina recognizes one main exception to contributory negligence, and it's called the last clear chance doctrine. It works like this. Even if you were partly at fault, you may still be able to recover if the other person had the last clear opportunity to avoid the accident and they didn't take it. If the other driver saw you, had enough time and space to avoid hitting you, and hit you anyway, your share of the fault may not bar your claim. Now that sounds like a meaningful protection, but in practice it's harder to use than it appears. To make this argument work, you generally have to show that the other person actually saw you in danger in time to do something about it. Not just that they should have seen you. And you have to show that they had a real opportunity to avoid the crash and failed to take it. That's actually a high bar to clear. It requires proving what the other driver actually saw and when, which is often very difficult to establish. And North Carolina courts have limited when the doctrine can even be used, which means it doesn't even apply in every situation. It's a real protection, but not one that covers every case where contributory negligence is an issue. So what does this mean for evidence and documentation? Because the legal standard in North Carolina is this strict, the way you handle evidence after an accident matters more here than almost anywhere in the country. In a comparative fault state, a gap in your evidence might reduce what you recover. In North Carolina, that same gap might be used to establish that you were at fault and eliminate your recovery entirely. That difference changes everything about how a case needs to be built from the very first moments after a crash. Photos taken at the scene of both vehicles, the road, the conditions, the signage, and where the impact happened are not just useful. They're the foundation of what gets argued later. If the insurance company can point to missing evidence and tell their own story about what happened, they will. Witness statements gathered quickly before people forget the details and become hard to reach matter a great deal. An independent witness who saw exactly where both vehicles were and what happened can be one of the strongest tools against the contributory negligence argument. What you say after the accident matters too. What you tell the other driver at the scene, what you write on a medical intake form, what you say to an adjuster, and what you say in a deposition months later all need to line up. Even small inconsistencies, ones that come from stress or confusion rather than dishonesty, can be used to suggest you're not being fully accurate about what happened. Getting medical care quickly and continuing that care consistently also matters. Gaps in treatment get used to argue the injury wasn't that serious, or that you were well enough to get by without care, which can become part of the argument that the injury was not as significant as you're claiming. Why does this rule matter beyond car accidents? Contributory negligence applies across all types of personal injury cases in North Carolina, not just car accidents. Bus accidents, boating accidents, bicycle accidents, pedestrian incidents. The same rule applies across all of them. A passenger hurt on a public transit bus who was standing without holding a handrail at the time of the crash could face a contributory negligence argument. A boater injured on Lake Norman who wasn't wearing a life jacket when another vessel struck them could face the same challenge. A pedestrian crossing outside the marked crosswalk who gets hit by a car is immediately open to a contributory negligence defense, even if the driver clearly wasn't paying attention. In every one of those situations, the question comes back to the same thing. Did this person play any role in what happened to them? In North Carolina, even a small yes to that question can end the case. Understanding the rule. Contributory negligence is one of the most important legal rules in North Carolina, and it's one most people only learn about after something has gone wrong. It applies to drivers, passengers, pedestrians, cyclists, boaters, and anyone who gets hurt in a situation where fault is in question. It shapes how evidence needs to be collected, how statements need to be made, and how medical care needs to be handled from the very first moments after an accident. The standard doesn't leave room for a middle ground. A jury doesn't weigh your 10% of fault against the other person's 90% and land somewhere fair. They make a yes or no decision, and if that answer goes against you, your claim is gone. Knowing this rule exists, understanding how it works, and recognizing how it touches every part of a personal injury case in this state is the kind of information that can genuinely change how someone handles themselves when something unexpected happens on a North Carolina road or anywhere else in the state.